Thank you all for being here today to hear us talk about the work we've been doing. We're really excited. We don't have a lot of child and family sessions often at NACM, so I'm always excited when we get to talk about what I would do, which is child and family work. I have been in court consulting at NCSC for about 2 years, and before that I was a researcher at the National Center for Juvenile Justice, which is the research arm of NCJFCJ. So I've spent a long time doing research and consulting work with juvenile justice and child welfare. And certainly when the pandemic hit in courts, as you know better than I, hurried to get everything going online and virtual. In child welfare, we had a number of courts that just kind of picked up what they were doing in person and just, now we do it online. And there wasn't a lot of guidance around how to do that, how to do it in a way that engages families, how to do it in a way that kind of keeps cases moving. So we got a lot of requests from people to look into how those child welfare hearings were going virtually, and that's what we're here to talk to you about today. We've been working on a study, a 5-state study. I guess it started back in November of 2020, and we were collecting data. Actually, I think we collected our last piece of data maybe 2 weeks ago. So it's been an ongoing study, and this is my 3rd time presenting on it, and I keep calling it preliminary findings, but I think at this point, these are the findings. We're finished collecting data, and we're looking forward to a next phase. And so we have some proposals out for what we want to look at next, which would be kind of case outcome data. What we're presenting to you today is just what we've observed in the courts, and we're hoping to be able to issue some guidance around virtual child welfare hearings moving forward, because we do think that this is something that's here to stay, and we'll talk about that a little bit later. So I'm going to jump in and tell you a little bit about, or a lot about what we found out, and then my friend and colleague Jeffrey is going to jump in and talk about the Texas experience, and Texas was one of our 5 states. Okay, I thought this worked when I tested it, but now I can't get it to work. One second. So I'll do this. There we go. All right. Yeah, sure. So our research questions. First, we wanted to find out what the experience of youth and family and court professionals were with virtual hearings. We heard a lot anecdotally about what court staff and judges thought about the virtual hearings, but we didn't have any information about what those virtual hearings were like for youth and their families, and for attorneys. And we also surveyed caseworkers, which we'll see in a second. So that was number 1. We wanted to find out what was the court user experience. Secondly, we wanted to know what extent were judges able to implement key aspects of quality dependency hearings online. So NCJFCJ's enhanced resource guidelines have kind of been the benchmark for what are high quality dependency hearings for a long time. And so we wanted to see if those aspects, such as asking people if they understand, making sure that they're using individuals' names and speaking directly to people, how does that look in the virtual environment? So those were the 2 areas that we really wanted to focus in on. This just shows our 5 states. We had Washington, Nebraska, Michigan, Arizona, and Texas. And so I've shaded the dark blue are the counties where we had 1 judge that participated. And it's kind of hard to see here, but there are 2 areas, one in Nebraska, Douglas County, and one in Washington, Spokane, where we had multiple courtrooms, which is important to note for later on. So we had 6 commissioners in Spokane and 3 courtrooms in Douglas County. And then in Arizona, you see the magenta is our only family treatment court. So the data from our family treatment court is not included in this study, but we will be publishing a short deliverable about it, which I thought was really interesting findings that we had from the family treatment court. One of, I think, my favorite findings was that there was a difference between, so we asked the question of participants, would you prefer hearings to remain online, or would you like them to go be in person? And the individuals who were in the family treatment court prior to the pandemic said, we want to go back in person. And the individuals who joined the family treatment court during the pandemic said, we're fine online. So if you know anything about treatment courts, you know that peer support is so important. And the individuals who were missing that, and that were started in person and then went to virtual, and those who were virtual the whole time hadn't really experienced it. So we are looking forward to looking more into that and seeing how we can build some peer support in our virtual environment. So we collected a lot of data for this study, and I'll point out my colleague Allie and Mackenzie in the background is in the, she was one of the people on our teams, and she is in the facility. She's a facility expert, so she offered a really interesting perspective as we start to talk about infrastructure for virtual hearings and what your court needs to have and how they look. So we had a good group of folks from NCSC who were collecting all of this data. We had interviews with judges in some of our jurisdictions where we didn't have enough attorneys to survey. If there were less than 10 attorneys, we would do focus groups. We also did surveys. Number one, parent surveys is what we really tried to get at. And it's one of the things that we're hoping to do better in phase 2. And this is a lesson we learned. We wanted to do electronic surveys. And what we realized was that the parents that were responding to our electronic surveys were the parents that felt comfortable enough with technology. And so they all have very positive things to say about the virtual hearings. So in our next phase, we're hoping to do more in-person focus groups and interviews to really talk to parents that maybe don't have the same access or technological skills to see if their experience differed. But I will share our findings from the parent survey today. We also did surveys of attorneys and caseworkers. You'll see the number of sites vary there. We had a lot of variance in where we got traction with our surveys. In places where we've had an attorney or a caseworker who felt very invested in our study, they would kind of be a gatekeeper for us and help us get more people to participate. Where we had trouble getting to that gatekeeper, we didn't have very good participation. So that's something else that we're looking to improve in the next phase. We observed in total 377 virtual hearings across 22 courtrooms and then 36 family treatment court hearings. And I will say 377 is a lot, and usually there is this kind of point of saturation where you feel like you've seen it all. But we didn't even feel like that because every courtroom handles virtual hearings so differently, even within the same jurisdiction. And so that was kind of our primary finding from the study was how different things happened. So it was not just different platforms, but different practices. And from what I think one of the biggest differences we saw, which is kind of illustrated here, our average hearing length overall, the average was 20 minutes per hearing. But when we look at the range, there were some jurisdictions where the average hearing length was 2 minutes and 40 seconds. And some jurisdictions where the average hearing length was over 43 minutes. So those two things alone can tell you a lot about how different those hearings are. I should mention too, we mostly saw review and permanency hearings. So most of this data is based on child welfare review and permanency hearings. We saw a couple adjudication and disposition hearings, but not very many.
How did you pick the sites?
Oh, thanks for asking. So we reached out to states that we knew had been doing virtual hearings for a while. We didn't want to bring on a state that had just started and kind of getting through their lumps and bumps at the beginning. So we reached out to a handful of sites of state court administrators who we knew had been doing virtual for a while. And we were really surprised, I think, by the amount of participation we got, because we knew, that was such a busy time for people, and that transition was really, took up a lot of time and energy. And so we thought for sure that people say, we don't have time to participate right now, give us a call in a few months. But everyone was like, yes, we want to participate. Pretty much everyone we reached out to said, yes, we want to participate. And you only want 3 judges? We'll give you more. And so we had an overwhelming response. So we didn't really have to reach out further beyond our first couple states. And we allowed the court administrator to choose the jurisdictions.
So were these sites that were doing virtual hearings prior to the pandemic as well?
No, great question. All new. So all who had on, and most of them had onboarded sometime between like April and May 2020. Oh, no problem. Please do. Any questions, just feel free to jump in.
And I'm sorry, maybe I missed this.
That's okay.
But what was the survey period?
Oh, yeah, it's a great question. So we started collecting survey data, and it was different for every jurisdiction. We started with judicial interviews in November of 2020 and completed them in January 2020. And then we started surveying in March of 2020, and we closed them. I want to say that we finally ended up closing them sometime around the end of, wait, I'm getting my months mixed up. Hold on. So we started collecting or doing those interviews with judges in the fall of 2020. We opened up the surveys in early 2021. Thank you. And then so we closed them, I want to say sometime in May, but it was staggered depending on how much response we got. We tried to keep them open to try to get more responses in sites, but it kind of varied among, as I mentioned, whether we had a good gatekeeper there that would help us access. We actually had a lot of attorneys say that they didn't want to participate. They would respond to my email and say, no, thank you. So I think it just depends also on kind of the culture in the jurisdictions, if there's attorneys are used to participating in this kind of work. Any other questions?
I'll just remind us that we're live, so if you can repeat the question or if you guys can hit that mic over there and turn it on when you ask your questions so our live folks can hear the questions as well.
Thanks, Julie. Sorry. And so one of the biggest differences that we saw is a difference that exists even outside the virtual hearing element, but that's whether courts schedule hearings time certain scheduling, so every hearing has their own time, or what we affectionately call cattle call, where you have one time and schedule all the hearings. We saw anecdotally in the pandemic, we saw a number of courts who were doing cattle call kind of transition to time certain because it's easier kind of in the virtual environment. But we did have a few courts in our study who stayed in that kind of one time, several hearings have one time, and that looked very different. So in the time certain courts, you would have courts that either every hearing had its own link and its own time, or there was one link per judge and people would just have a different time and be in the waiting room. In the kind of cattle call situation, everyone might be scheduled at 1, everyone comes into the Zoom room at 1, and what typically happened was that people would keep their cameras off until their hearing was called, and then their camera would come on. So there would be times that there would be 40 or more people in a Zoom room waiting for their case. It depended, I think, whether it was a closed hearing state or not, but that did create it was very different environment, and it had a different feel for us. So that's just one example of the things that were very different. This slide, I just showed a couple. I wanted to point out a few other differences we saw. Aside from how hearings were scheduled, a second big difference was expectations around camera use. So we saw a full range from one jurisdiction we're in where the judge was the only person on camera for every single hearing. No one else ever turned their cameras on. To another court in another state where that judge required everyone to have their cameras on. So if you showed up without your camera on, you were told to put your camera on, and there was something in the chat that said, turn your camera on. So we saw a full range of that. And so that I'll talk about a little bit more in a minute, but I think has a lot of implications to what that experience is like for court users. Judges' camera placement. I will say most of our judges use the camera or the webcam on their computer so you saw their face. But we did have judges that were using cameras that were set up for security reasons, and you kind of saw an overview of their head and into the courtroom, and you couldn't see their face. We had other judges that used a camera that was maybe placed across the room through plexiglass, and you kind of saw a profile. And so I think that was really based on just picking up your hearing and putting it online and not thinking about those kind of logistical aspects of it. Instructions for participation. One of our survey questions was, How did you learn about instructions? Most parents that reported learning from their attorney. Some of the courts that we were in actually had instructions for how to use it in the waiting room or instructions in the chat box. Not all courts did that. And I was in some hearings where court professionals would use the chat box, but that wasn't something that happened often. And you'll hear later that one of our biggest technology kind of, we tracked different technological issues that we saw in our observation. And one of the most frequent one was inability to use the platform or not knowing how to mute, unmute, enter rooms, and so on. Just quickly, levels of formality. Of course, that's true even in the in-person world, but we saw a variety of levels of formality for judges who would say, this is just like another hearing and require a lot of formality. And then in our judicial interviews, we heard from some judges that they realized that there's, this is a different environment and there's a lot of stress, and they will allow some more leniency, not so much around what people wore, but maybe where they were, what they were doing. We heard anecdotally from a number of judges in our interviews about individuals smoking, and there was a lot of feelings about, is that appropriate or not? Are those coping mechanisms that are available to individuals who are doing a hearing from their house, should we let them do that? So that was a lot of difference of opinions that we saw. Inconsistent practices for interpreters. We did not have many hearings at all that had interpreters, unfortunately. But what we were able to notice is that every time we witnessed an interpreter, the way that they operated was very different. We had everything from an interpreter being on video and repeating kind of in real time what the judge or attorney was saying, to an interpreter who muted themselves, called the parent, and talked to them over the phone, and also interpreters who were in the same room with the parent. So we saw a lot of differences. And I'll actually be talking with our language access team at NCSC about how we can add to this study around language access as well. And then finally, the other biggest difference we saw was who was in charge of the technology. We had a handful of jurisdictions where we had one judge, in fact, who called himself IT. And he was in charge of letting people into the waiting room. He was in charge of making sure everyone worked and set up, and kind of liked that. But we had other jurisdictions where there was an individual who was responsible for doing that, kind of letting people into the waiting room, making sure everyone could hear, making sure everyone knew how to operate the platform. So we just saw a lot of differences there. So I wanted to make sure, one of the reasons I emphasize this point about how different it is because it made it really difficult for us to aggregate all of our information together, because there are so many nuances around this. So when I present, you'll see in a second, I present not just kind of what our overall average is, but also the range of what we saw in the states. So that besides everything being so different, the second kind of biggest takeaway from our study is the controversy, I'll say, around video participation and audio participation. And there are three kind of major themes that we took away. Number one, in terms of equitable access and equitable experience, most of the time our parents were joining, if they were joining by video or by audio only, court professionals are almost always on video. So if a parent is joining by audio only, they're missing out on a lot of contextual clues. And by audio only, I mean a number of parents just call in the Zoom line and they don't show their face, and then they can't also see faces. So they may not know everyone who's in the hearing, what their names are, who's speaking, and they miss out on a lot of contextual clues that other people who have the benefit of seeing faces pick up on. So there's a little bit of issue of equity there. Secondly, we heard from our judges how important it was for them, especially to hear testimony, to see people's face on video. And so it was important for most of the judges in our study that people were on video, but you'll see later, most judges didn't ask people or encourage them to be on. And then finally, there are some kind of implicit bias considerations for the video versus audio debate. I'll say number one, if you have ever, so there may be perceptions that you have about someone who joins, is the only person joining by audio and is not joining by video. You might think that, oh, they don't, implicitly you might have some negative connotations to that. Secondly, if you have ever been on a meeting where someone joins by their cell phone, you'll see how it's moving around, they're maybe holding it, as opposed to most court professionals are joining these hearings by a device that's stationary. So your Zoom block stays square, right? And it stays kind of still. So that movement can also create some kind of implicit bias. So I'll also say, if you have not joined one of your virtual hearings by a phone, I encourage you to try it and see, because the functionality and the view that you get on your virtual hearing platform on a phone is very different than what you have on a computer. And so you might not have the same access. A lot of times on the phone, you can only see the speaker. You can't, you have to scroll through to see everybody's faces. So it is a little bit of a different experience. And you'll see in a second, most of the parents who are joining by video are joining by their cell phones. Oh, and there. So these are how I opted to do our graphs, because I wanted you to see the range of responses across our courtrooms. So the bar shows kind of the range of, for example, here in the first bar, in one of our courts, only 10% of hearings had a mother present. And on the high end of that, on one of our courts, about 75% of their hearings had a mother present. So that gray bar shows the range of courts, because we have very different responses for all our courts. And then the box in the middle shows the average. So in all of the 300 some hearings that we observed, in about half of them, the mother was present. And when a mother was present, she was present by video in 57% of the hearings that we observed. Same for fathers. In all of our, overall, fathers were present about 38% of the time. And when they were present, 61% of the time they were present by video. So a couple things about this. Number one, we heard anecdotally, and I still do, I hear over and over again that parents are more likely to show up to hearings if they're virtually. Our data does not show that, and we hope in phase 2 we'll be able to do a comparison. We don't have this information for our courts from before the pandemic to compare to. And one of the limitations of our study was that we don't have the case file for the hearings that we observed. So we didn't always know if both parents or one parent was supposed to be present. So that's a limitation that we hope to address in the next phase. But generally, we didn't really see a big increase from what we would typically see in prior studies. In our survey, most parents report, as I mentioned, report if they are going to be by video, they're by video by smartphone, which I think is an important point to consider. And not only did we hear from judges, but also most attorneys and caseworkers also believe that parents are more likely to appear in person, appear in hearings when they are virtual. We really wanted to get at the experience of kids and children, young people in their hearings, but unfortunately, we didn't see many of them in our observations. We only had about 15%, 16% of the hearings that we observed had a kid present. And when they were present present by video about half the time. I'll say most of the time they were with somebody. They were with a caseworker or a placement provider who often was the one that helped them get online. We did interviews with some of the youth, not as many as we would like to, but the youth that we interviewed talked about that it wasn't very difficult to log on. Sometimes they had trouble logging on because they would get a wrong passcode from somebody and would have to kind of reach out last minute to get a different passcode. But in general, they didn't have as many issues accessing as were reported by parents. I'll also say that this 16%, when we asked caseworkers and attorneys if kids were more likely to appear virtually, they said that they've noticed no difference. So it's really more of a kind of a court culture, whether kids are there or not. And you'll see here too, like we had several jurisdictions where we never saw a kid in what we observed, up to nearly just under 50% was the most. And that was a permanency court, so most of those kids are legally free. that were in that court. So I showed this information about attorneys, that's district attorney, mother, father, and child attorney, to show most of the court professionals who are in hearings are by video. And again, they're almost always by video by a stationary device. They reported in our survey that sometimes they would use a cell phone, but most of the time they were on a desktop or a laptop. And then one of the things that we had also hoped was that the virtual hearings would mean that more individuals who would maybe not readily have access to in-person hearings, but our support folks for the family would be able to come to virtual hearings. And so you see here, we looked at how many of those hearings had caregivers, relatives present. We had about 34% of our hearings was there a caregiver, and those caregivers were almost, and that would be foster parent or kinship caregiver, and those individuals were almost always present by, or 75% present by video. We only had 8% of the hearings where there was a relative that wasn't a caregiver, and about half the time they were present by video. And then you can see we only had about 4% of our hearings where there was an interpreter, but 78% of the time that there was an interpreter, they were by video. And so in all of our courts that had an interpreter, at least partially, part of the time they were on video. And then tribal representatives, we only had in 2% of our overall hearings, and they were present by video 60% of the time. So then at the beginning of our study, we started to think about what are some practices that we think would help kind of transverse this in-person to virtual hearing environment. What are some things that judges might be able to do to help kind of ease that transition? And we came up with these 4 practices based on our interviews with the judges in our jurisdictions, and that's confirming all parties are present, making sure everyone's sound works, providing instructions for using the platform, and asking parties' location. That last one I think was particularly important because we had heard anecdotally at the beginning of our study that a number of parents were joining by work. It was so great they could join at work, they could join wherever they are, but there is an element of privacy then that is somewhat lost. So I have observed some hearings where a mom is joining in break room in a fast food restaurant, for example. Is she in a private space? Is she without distraction that she can meaningfully participate in her hearing, right? So that was something that was very important to us to think about, not making sure that even though the convenience of virtual hearings allows people to attend more, does it take away from their ability to meaningfully engage in those hearings? So these are things that we tracked in all of the 17 of our courts. There are a couple of our courts that we didn't track this in. And so the black dots each black dot represents one court. And so most of the time is if they did it 75% of the time. Some of the time is if they did it between 0 and 75% of the time, and never, obviously, they never did it. So we had most of our courts confirmed all parties are present most of the time. Where we tended to not see this was courts that used what I refer to as a cattle call. So people where there was a number of people from a number of different cases in that Zoom room. They might not do that as often. Confirming everyone's sound works. This, I was in a handful of hearings, where we were several minutes into the hearing before we realized that somebody couldn't really hear or that we couldn't hear them. So making sure that people's sound works early in the hearing was something that was important for us. And that could easily be done, at the beginning while making sure people are present when they announce themselves. So that kind of happened. There are 3 courts that did that frequently. Providing instructions kind of varied across all of our courts. Some courts, as I mentioned, had instructions clearly outlined in the chat box of their virtual platform, and others we have examples that we'll provide in some of our deliverables about instructions that they sent out with their hearing announcements. But this ask parties location, we didn't have any courts that did it most of the time. One court did it some of the time, but usually only if it was pertinent. Like if somebody was walking, one time I believe a woman was walking around a mall with her phone. And the judge then asked, "Can I ask you where you are? Can you sit down? This is a little distracting." But but we didn't see that happen often. Yeah, sure.
Do you think that happened because there were instructions shared previously that they ought to find a private place? So it wasn't like, that's why we're not seeing it then, but it was communicated prior to the hearing?
Yeah, that's a good question. So the question is, do I think that that's because there were instructions about where to be located, be in a private place? Maybe. I think it's true. A lot of the instructions I saw were limited to click on this link, enter this passcode. I think as our study progressed, I did see some examples of courts who refined their instructions. One of our courts in particular had very thorough instructions at the beginning, and even refined them further and included them both in the announcement that would say things like, dress appropriately, be in a private place, limit distractions. And then that information would also be in the chat box. So I think that varied a great deal. So then a couple other things came up when we were thinking about ways to transition to the virtual environment. Number one, we thought, from talking to judges in our judicial interviews, acknowledging the virtual environment was important. So one key aspect of trauma-informed hearings, is to be very transparent. And the virtual environment is different. And we can try to, it's still a hearing, but it is different. So we did have some judges who would say to individuals in their courtroom, "I know this is different. I hope to see you again in person someday, but this is what we're doing right now. It's the same as a courtroom. It'll be my turn to talk, and I will let you know when it's your turn," things like that. And I think that was very helpful because we heard in some of our surveys and also interviews with youth that it could be very difficult to follow a hearing virtually, more difficult than it was in person. And then I mentioned previously about the encouraging parents and youth to be on video. It didn't happen very often. And I think that that's something that all courts should kind of consider what their philosophy is on video and audio. I do think it enriches an experience to be on video, to see people and have that connection. But there are also some things that might be that I've heard from some court professionals about not wanting to, see things they're not supposed to see, and somebody is in their home environment or somewhere else. So I think it's a court-by-court decision, but we would, at this point, suggest that people consider asking people to be on video if that's something that's available to them. And most parents that we talk to are joining by smartphones and do have that capacity. So then this is the part where we talked about the different aspects of quality dependency hearings based on the enhanced resource guidelines from NCJ-FCJ and on trauma-informed courtrooms. So we wanted to see if judges explain the purpose for their hearing. And again, I don't have the information from our courts to compare before or after, but essentially it's very possible to explain the purpose virtually in one of those ways, similar to acknowledging the differences between a virtual and in-person hearing. And we saw some of our courts did that frequently when mothers were present, when fathers were present, and also when children were present. The second aspect that we were looking at was speaking directly to the parties. And again, this is much easier when you're on video and you can talk to somebody. But in all of our courtrooms that we measured this, when mothers and fathers were present, at least some of the time they spoke directly to the party. But there was one courtroom where they did not speak directly to the child when children were present. But most of the time this was possible. I heard one of our judges in our interviews say, "It's so hard because I can't tell if they're looking at me or not." And so but if all you see is a black box, then you really can't tell. So I think another reason why it's helpful to have video. And then third, did they address individuals by name? Again, this is something that is in the ERGs and encouraged as a best practice, and it does happen frequently in our courts for mothers, fathers, and children when they're present. And then giving individuals an opportunity to be heard. I think sometimes attorneys get nervous about this, especially in a virtual environment. I had a number of attorneys tell me, in person, I can grab my client's arm or kick them under the table and tell them not to talk, but I'd have no way to do that virtually, which is true. We'll talk about that in a second. But in most of the courts rooms, they did offer mothers, fathers, and children the opportunity to talk. I think sorry. Okay, that's okay. All right. And then finally, how often did judges ask individuals if they had questions or if they understood next steps? That happened much less frequently, but that's something that we see less frequently in person too, right? I think that's up to judicial practice and individual culture. So, but those are all, I think, telling that those key aspects of high quality dependency hearings are things that are all possible virtually. So I mentioned the communication with attorney. Most individuals that we talked to, or most of the parents who responded to our survey, said that they got instructions on how to join from their attorney. And so that might be the amount of instruction they're getting, to your question earlier, right, could vary based on what attorney they have. In 8 of our 17 courtrooms where we measured this, parents were observed communicating with their attorney. And so that's what we could see. Most often that was either in a breakout room, the judge might take a recess and let people call each other. But what we found when we surveyed attorneys is that they were able to confer with their client every time or almost every time that they wanted to, usually by text message. We did not have any record of a youth communicating with their attorney during none of our hearings where there were youth involved. Did they ever communicate that we could see? But here, about 50% of the time, attorneys said every time or almost every time I wanted to talk to my client, I could. And so again, you'll see at the top, most of the time it was by text message. In the jurisdictions that enabled breakout rooms, which was not all of the jurisdictions in our study, that's just another difference, right? They used the breakout rooms. Sometimes they would do phone calls. There were a handful, I'll say, of our, just kind of in reflection, there's a handful of our courtrooms where we would see an attorney with their client, kind of both on the camera, sitting separate. But that didn't happen very often. And so we surveyed attorneys across the jurisdictions. Most of them, there's a wide range of how much of their caseload was child welfare. Most of them said it was very easy. We hear anecdotally from judges that it was the attorneys that had the hardest time making the transition. And caseworkers also said that it was pretty easy, very easy. 61% of caseworkers said it was easy for them to connect. The most difficult thing for caseworkers was being able to hear everyone speak. And I think going into the study, we thought that there'd be a lot more technological issues than there were. And a lot of people said like one of their number one fears was all the technology breakdown. But we actually saw much fewer technology issues than we anticipated. So 16 out of the 17 courtrooms where we tracked this had some kind of technological issue. And this could be anything from someone freezing, somebody getting kicked out or booted out of the Zoom room, to like user error, someone not knowing how to navigate the platform. We counted all of that. And so in about 1/5 of hearings was there at least one technology issue. And if you think about all the Zoom meetings that you've been on in the past year and a half, that's not that much. I had a Zoom room this morning that I had to quit because I kept getting kicked out, right? So really there's not that much technological difference. Most of what we saw was a poor Wi-Fi connection. And that typically took about 3 minutes to solve. We saw 15 kind of technology issues that were lack of knowledge of the platform. Often people who didn't know how to mute or unmute themselves, or were using their cell phone and couldn't navigate it. And that typically took about 4 minutes to solve. Background noise or difficulty hearing, 14 of those. And some of those were actually parents who were incarcerated who were not able to mute themselves because the jail phone did not have a mute button. And then difficulty accessing the hearing or getting kicked out, couldn't log in or got bumped out. Those took about 3 minutes to solve. And when individuals were frozen, that happened about 14 times. Often what would happen is that it's similar to a meeting that we would be in, we'd wait the customary like 30 seconds or so, and then the judge would continue on with someone else if possible, or or that person would call back in. I never saw a hearing completely end because of technology issues. And I just put this up anecdotally that a third of all the issues we saw were actually attorney issues, not parent issues. And the second, followed by a fifth, were issues that the mother had. So finally, the big picture is asking these court users what works well in virtual hearings. And the adults, the parents, the attorneys, and the caseworkers, their reasons of what works well kind of has to do with convenience. So I don't have to travel anywhere. I don't have to spend any money to travel. What was interesting is that in the interviews that we did with kids, they also said, oh, I don't have to leave my house. But number two was it reduces my anxiety. And they felt like it was less intimidating to be from home or from placement or somewhere in school, being somewhere else outside the courtroom to have those hearings. We did not hear that from parents. What was difficult for parents and youth? So we asked parents what was hard. Number one, like by a landslide, was nothing was hard. Again, I'll remind you, these are all parents that felt comfortable enough with technology to do an electronic survey. So it's a little bit of a biased sample. And then we also asked youth what was hard, and they said it was hard to hear people speak. Everyone spoke over each other. We didn't know whose turn it was. I was a little disorganized. So that's what we heard from the youth interviews. Attorneys and caseworkers said that what they thought was difficult for parents and youth were either parents lacking equipment or internet accessibility. And one of the judges I talked to, when I asked, well, do you think that parents are coming more? He said, I think the parents that came before are coming still. I don't know if the parents that aren't coming for other reasons or aren't coming because they don't have a connectivity. I have no way to know that, which I think is true. So we have some work to do to think about that subgroup of parents who maybe aren't accessing because they don't have connectivity. I will add, we had some rural jurisdictions and urban jurisdictions. So we didn't see a big difference between our rural jurisdictions and the people present or how they were present or the technology issues. We didn't see a significant difference. And then we did ask, comparing online hearings to in-person, is online better or is there no difference? And as you can see, parents said online is better. Again, the gray is the range, right? So in our courts, we had some courts where no parents said that in-person were better, and some courts where nearly 80% of our parents said in-person was better. That was a huge range. But overall, by the averages, most parents, 42%, think online is better. When we asked attorneys and caseworkers, about half said it depends on the type of hearing. And that goes to some of the things that will be coming out in our considerations. I'll go back to that one in a second. I just want to go here first. So some of our considerations were hearing is that courts should consider if there are specific hearing types that are better to be in person versus virtually. Review hearings and things that kind of like pre-hearing conferences are for most of the people we talk to and most of our observations, very well situated to be virtual. Where we stop into some hearings that might be better off doing in person would things be like termination of parental rights, adjudications, any kind of testimony. It seems as though the judges in our study, as well as the court professionals in our study, think that those types of hearings should remain in person. Sure, yeah.
Did you see or did you ask about like going into what are called shelter hearings, like removal hearings?
Mm-hmm.
Was there anything? I've seen a lot of studies on virtual versus in person, but I haven't seen many studies talking about shelter hearings.
Yeah.
And so
Yeah.
I was wondering if you guys talked about that or found any information on that.
Yeah, good question. So the question is, did we look at shelter hearings? So we unfortunately did not get to see very many shelter hearings because all of our hearings were kind of pre-planned. So we would say, what hearings do you have this week? And then they would send us the links to the hearings that we had. So a lot of times the shelter hearings aren't on that kind of regulated schedule. So we didn't get access to many. We saw a handful, not enough to draw conclusions from or difference. But that's certainly something that we're thinking about for our next phase. One of the other kind of considerations that we are asking courts to think about is how they send their instructions and what instructions they provide ahead of time. And so we'll have some things coming, some deliverables coming out in the next couple months that will provide some examples from the courts that were in our studies. And then also, as I noted, acknowledging that the virtual environment is different than in person, and at least acknowledging that and being transparent towards the families can be very helpful. And then finally, hybrid hearings. When we started this study, there weren't a lot of hybrid hearings going on yet. And we accidentally observed some, usually if a parent got confused and showed up at the court and the judge said, just come in, we'll do it this way. And so what that led us to consider is how important the infrastructure for hybrid hearings are, to make sure, if we have heard, again, anecdotally, that a lot of courts are going to be moving towards more hybrid hearings because of the time that hybrid hearings or that virtual hearings save for a lot of court professionals, especially caseworkers. So in that situation of hybrid hearings, making sure that there is the technology so that everyone participating can see everybody else and hear everybody else. A few of the hybrid hearings that I accidentally observed, the parents were in person and nobody could see them and they couldn't see anyone except for the judge. And often we couldn't hear them well either. So thinking about ways to set up the courtroom and technology to make sure that everyone has equitable access to what they can see and what they can hear is important. And I just wanted to go back here. One of the other things, just kind of as an aside that we measured and considered through this study, is how often the pandemic was mentioned in the hearings and mentioned as something that impacted the case in some way. So in about 16% of all of the hearings we observed, did someone mention the pandemic, which I thought was kind of low. But I guess it just didn't come up in conversation. But the most of the time when it came up because people were unable to access services that they needed. So often that was a caseworker talking about how a service that the parent needed was not, or the youth wasn't available. Sometimes, and was about difficulties communicating with incarcerated parents. We saw both sides of the coin here. Some of our jurisdictions said they had better communication with incarcerated parents during the pandemic because the jails or the prisons had to create those lines. So they were able to include them more, and they didn't have to transport. Other jurisdictions said, we can't get them on the phone now. It's too difficult. In a couple of our cases, we had parents, children, or caregivers actually having COVID, which impacted things about the case. And certainly barriers to visitation. We've all heard about the virtual visitation and child welfare, but also aspects like if the grandparents were the safety plan, but they were high risk and didn't want to contract COVID, they might not be as willing to participate. So that's really what we heard kind of in the discussions in the hearings. And so before I turn it over to Jeffrey, I just will note that we have a couple briefs that will be coming out that are in development right now about this study. So you can look for them to come out soon. And then, as I mentioned several times, I feel, we have a phase 2 that we're planning. So I'm open to any ideas or things that you'd like to hear more about in phase 2 as we develop that. And for now, I'm going to turn it over to Jeffrey.
So you're probably wondering why this guy was sitting up here the whole time during Teri's presentation. When Teri and her colleague Chris reached out to Texas, back in the day, and they said, "Are you interested in participating?" We jumped at the opportunity because we knew with the pandemic everything was changing so fast, and we wanted to do everything possible to capture all the data and all the research and all the information we could, because we knew at some point it was going to change, whether that was going to be back to the way it used to be in person, hybrid, or what have you. So We didn't have the resources, and we said, sure, if you want to do this, that's great. And I think we all know one of the great things about these virtual hearings is that most of them, if not all of them, are being broadcast somewhere. So before you had to travel to a courthouse and actually sit in someone's courtroom to observe court, and now we can just flip different URLs and just see what's happening in our courtroom. So that's the way I think Teri and her team captured a lot of their information. They never left their houses, and they were able to capture all of this data and study all this information. So we said, absolutely, we want to participate. So in Texas, most of our child welfare cases are handled through what we call our child protection courts. We have 31 judges across the state of Texas. In Texas, they're called associate judges, and they're actually employees of the state, and that's just the way Texas does things. Those judges, 31 judges, serve over 137 counties. To give you a sense of that, Texas is so big, 254 counties. Not all of our counties are served by these types of courts. They just don't have the need to justify the state hiring a judge to cover that county. So our judges only cover part of the state for child welfare cases. We have judges that will cover, as you can see in the pink in the middle, about 8 or 9 different counties. That's not unusual for these judges. So our child welfare judges generally do not sit in one courtroom every day for the week. They usually travel quite a bit. So the idea of hybrid hearings or remote hearings was actually pretty favorable for those judges because they didn't have to be on the road that much. There are no hearings conducted. If there are hearings that are necessary, if they're necessary, the district court judges in those counties would take those cases, but they're not dedicated dockets like ours are, and they don't have those dedicated resources, unfortunately. So again, we only cover 137 counties. A couple of just high-level observations that we were able to pick up, and the first one you probably heard this morning at the plenary was that we've seen the no-shows and appearance rates really flip-flop, particularly for these types of cases. And that is not true for many other case types, but particularly for these case types, that was something that was almost immediately seen, and that hasn't really changed across the board. One of the other things we've noticed is every court across the country is experiencing a significant backlog, but to our recent studies, our child protection courts are actually current. They're not experiencing the backlogs anymore because we knew those were the types of cases between child protection cases, child support cases. Those were really suffering, particularly during the pandemic. So we put a lot of emphasis to make sure that they were up and running. They had the resources to hear their cases, and they would pack their dockets full of hearings just to keep the cases going because those judges knew the importance of time during the pandemic. Those 37 judges, we recently reached out and just asked them a few questions just to sort of get a pulse of what they were thinking going forward. So we asked them, in your courtroom, because our judges run their own courtrooms, although they are employees of the state and we have oversight, they run their courtrooms, they administer all their hearings. We asked them, what do you see for the future of your dockets for child protection cases and child welfare cases? You'll see that it's split. It's sort of all over the board. Our child welfare judges range in skill sets. They range in ages. Some of them have been with the state for 30 plus years. Some just got on board right before the pandemic. I don't know how well any of those generalities sort of line up with what they prefer, but it's very mixed. The judges know that there's a dramatic increase in appearance rates, and they know that there's a dramatic efficiency for their dockets, but it's difficult, and we all know that. So for these judges to coordinate with all the parties takes a lot of time. Our courtrooms are also completely different. There's no courtroom that is the same in any of our locations. We have judges that are sharing courtrooms with other judges in those counties that they travel to. So one of our difficulties is how do we get them set up for the future? So we asked them, is your courtroom equipped for hybrid hearings? So a good portion of them felt like they were equipped. Most of them had no idea. That's not their job. That's not their expertise. They don't really know what's required. they know for us, we got them set up with a Zoom link, and they were off and running. So we have a lot of work to do there. In terms of docket setup, and I think that was really interesting because Teri talked about this, we asked them what they picture their future dockets to look like, and only a third are really still focused on these individual hearing setups. Almost half of our judges still prefer the cattle call, and it is just, it is a characteristic flaw that we cannot change really easily. Judges are just used to that. I mean, I've worked in general jurisdiction criminal courtrooms, and that's the way a lot of judges prefer it. They want to get everyone there because in those in-person hearings, oftentimes you can get people talking, right? You get attorneys in the room, you get people in the room, time is ticking, so things start to happen over the course of time. So a lot of our judges still prefer that. And so like Teri said, you'd have a computer screen full of little boxes, full of people and full of names and full of iPad X and Galaxy whatever phone. So it is something that we don't encourage, but it's something that is still happening.
Jeff, if I could, sorry to interrupt.
No,
You must be an open record state then?
we are. Yep. I put this on here just to talk about how important it is to be studying this. You'll see on the upper left, you have a child sitting in a chair, and next to them is an iPad. And that's kind of the perception, is we're all talking screens now, but that's really not the way that child should be experiencing this hearing. They should not be going through this process like that. There is a meaningful experience to go through this in person and to be with judges and to be with attorneys and CPS workers and the whole lot of them. There's something to be said for that. And that's why I think it's really important to continue doing this research and doing this study. This was brought up this morning. I kind of got frustrated because in the plenary they showed this, but you all know this screen. So this was, if you don't know, this was an attorney out of Alpine, Texas. Alpine's 6,000 people. It's a very small town. It's a lovely town of 2 restaurants that are closed half of the week. The judge that covers this county was actually the second judge in the entire state of Texas to start doing virtual and remote hearings. So for us, that was really telling that a judge in one of our most rural jurisdictions was able to pick it up with technology and do it. The reason I bring this up is because technology is hard no matter who you are. This was an attorney who used to be the city attorney for Alpine, Texas, and he had no idea. I was talking to this group earlier that I actually tried to replicate this after they did, and I couldn't even figure out how to do it. So to say that it's hard for attorneys, and that was in your study as well, that attorneys tend to have more of the technical problems, it's hard for the judges too. It's hard for everyone going through this. It's a good laugh, but it's just, I think a lot of judges and attorneys feel the same way that Kat feels right now. Like, this sucks. This is awful. And we're trying all we can to make it better. I was in Allison's session yesterday about the future of courthouses and space planning, and the question we're getting every day is, what do hybrid courtrooms look like? And I actually wish I could find a session that will give me that answer, and I wish maybe someone has that answer here. But when you deal with space phones, that's the way courtrooms used to be set up for telephonic hearings. You've got the microphone over there that used to flip on and turn off so someone didn't hear you. We still have litigants on flip phones. We have big screen TVs to display people, iPads. We have judges sitting in front of 7 monitors for all the different things they're dealing with, whether that's dockets or attorneys or their case management system. We just received, it's a very small, but a $10,000 grant from our Children's Commission. They said, here's $10,000, find 2 child welfare courts in the state, and outfit them with whatever they need, because they realize that this isn't going away, this isn't going to change, so we need to make this as good as it can get. And so we're looking at technology, we're looking at cameras to say, what is the best setup? Because what you observed in the few hybrid hearings you saw was everyone needs to be able to see everyone. Everyone needs to be able to hear everyone. Throw in interpreters, throw in sign language. There are a lot of factors to consider, and we just don't want to set our courts up for failure. So we're in that discovery phase of what is the best setup. And when you have courthouses in rural areas that are close to being on dial-up, When you have courtrooms that just were built in the early 1900s that just aren't set up for this, it makes it difficult. And we're out to figure out how to make that work. This is one thing that the state of Texas is exploring. So when the pandemic hit, Texas jumped on it and said, here's Zoom licenses for everyone. We'll figure out how to pay for it later. And we got judges all across the state up on Zoom. We actually have David Slayton, our state court administrator, actually has a seat at the table working with Zoom to give them regular feedback about enhancements to their product that will help courts from our observations. This is sort of a spin-off company. It's zConnect. Their URL is zconnect.io. And what they are is they're sort of an add-on to Zoom to do virtual lobby management. So what we've heard from courts is it takes a lot of time to manage all this. For all the people coming in on their iPads and phones and computers, and they have names or they don't have names, just the logistics of getting that set up for a judge, and sometimes our judges are doing it, it takes an incredible amount of time. So we've been looking for solutions to make that easier for the courts. So this was a product that we sort of came upon when we were working with Zoom. It's something I would encourage you to check out. They're new. They're actually sort of developing as they go. And so what they're charging us is very nominal. But we've piloted it in just a couple of courtrooms. And one of our child welfare courts says it literally saves their court staff 2 to 3 hours per day, just handling the back-end logistics of getting all the litigants through the hearing process for the day. And that's one of our busier child welfare courts across the state, but it's saving the staff a tremendous amount of time so they can focus on other things. Teri was talking about the second phase of their study. We're also looking at how can we take this a step further. We got a grant for $300,000 from the Children's Commission to take it further. This study was very qualitative and observational. We want to continue that. We want to build upon that and do some quantitative study to see resolution for these hearings, length of time for the hearings. We want to go back before the pandemic started. We want to go a little further sort of post-pandemic and just sort of look at the big picture. The commission has charged us with looking at truly the efficacy of remote hearings in child welfare cases. Just because people can show up and just because they have access, is it really good for the litigants? Is it good for the kids? Is it good for the parents, for everyone across the board? So we're hoping to start that here in the near future. We're hoping to partner with Teri and her team on that, but we feel like this is important to study just as much as everything else is important to study, and just take some of these research findings and take it a few steps further. And that is our presentation.
I just want to add one thing that one of your slides reminded me that I forgot to say. So the slide, the picture that you had of the kid talking to the iPad. So I showed the slide where it had most professionals and parents think that online is better. They'd like to keep it online, at least for some hearings. The only people that we heard from that said they wanted to be in person were the kids. So out of about 70% of the kids that we interviewed, which was a small sample, said that they wanted to go in person. And so I don't know how much that is that they were maybe missing just social connection in general, because that was right in the middle of the pandemic. Many of them were out of school, didn't have a lot of connection, or if it really kind of goes to show the power of a connection with a caseworker or a judge or an attorney. But the kids were the ones that we heard from that wanted to go in person. So I do think that that's something to consider as we kind of navigate what this next few months look like, or next few years look like, with the ability to have virtual hearings balanced with how meaningful are those hearings for our kids and for their families. So I just want to make that point. Happy to answer any questions you have.
Teri, I found that really interesting considering they were also the ones that said they had less anxiety being online. So I find that very interesting. But do you guys have any questions? I can bring the mic to you so we can make sure they hear the questions.
I have another question. Apparently I have a lot of questions today. But so when you were looking at all the different video hearings, I believe you mentioned there was a time where you started seeing individuals back in the courtroom. I'm interested to see what percentage of hearings you had with everyone remote. And if you looked at that, I just think it's going to be so interesting if we can run court from home. You know what I mean? And I think I don't know. interested in that, and see if you had any percentages on that, or if you're planning on looking at that later on.
Yeah, so absolutely, hybrid hearings are part of our phase 2 because I think that so many courts are moving in that direction. We did not, so I don't have accurate, I can only kind of guess what I saw. And the lion's share of our hearings that we observed, as Jeffrey mentioned, we were home observing and everybody was virtual. However, even in some virtual hearings, some of our judges were in chambers or in their office or on the bench, even if we called it a virtual hearing if everybody was on Zoom. The hybrid hearings we saw, and again, I'll say they were accidental because we would ask we would ask the court to send us the links for their hearings coming up. And so very few hybrid that we saw, but then again, things were just starting to open up, kind of towards the end of our study. Most of the time, if it was hybrid, it was parents in person, everybody else at home, or parents in person with the judge, most other people at home or their offices on Zoom. I'm trying to think, occasionally we would see, as I mentioned, a parent with an attorney together in the same room on the Zoom screen. But, and I would say also, most of the time, our parents reported in the survey that they were usually at home, and that was our experience too in our observations at home or in an environment. We did see several parents at work or place of employment, only a few in kind of what we would consider maybe inappropriate places like the mall or a bus stop. One time a guy was plowing snow and said at the beginning of a hearing, "I'm plowing snow, so if I don't answer right away, that's why." So there was some of that, but most of the time people were in kind of like a closed room. In our next phase, we'll certainly be looking at hybrid hearings, especially around what kind of practices can we have in the courtroom to make sure that it's equitable, everyone has access to hearing and seeing, and that it's taking trauma-informed court experiences into consideration.
Thanks. This is kind of a geeky research mechanics question, but did the judges announce your presence, your eavesdropping to the parties?
Absolutely, yeah, that's a great question. And we always, when we do observation, when we talk to the judges ahead of time, give them the option, how would you like for us to, how do you want to introduce us, or how do you want to work that? And judges usually will ask permission. It depends on the state and if they're closed or open hearings, right? So in Texas, for example, after a while, judges might just say, we have some observers here from NCSC, and that would be it. We'd always enter with our cameras off, and instead it wouldn't say Teri Deal, it would say National Center for State Courts or NCSC, so we were kind of anonymous, and the judges would kind of announce us. In states that it wasn't open, they would have to ask for permission. In some of those states, they would tell the attorney, they would have sent a letter out to attorneys or email ahead of time announcing their participation in the study and asking the attorney to make sure it was okay with their client.
Did parties ever say no?
Not in this study. We didn't have, I think, maybe one or two, like very few. But I was doing a simultaneous study of virtual hearings in another state, and I got kicked out a lot. So, but usually people don't say no, but in that state they didn't like me there.
We are just a minute before our time. Are there any other questions? Well, thank you guys so much. Thank you, Teri. Thank you, Jeffrey. That was amazing. Thank you very much.
Oh, thank you. Thanks. I'll just add, we do have a tip sheet on our website, which is very long, but if you Google NCSC Study of Virtual Child Welfare Hearings, there's a one-pager tip sheet that please use it, share it, and you can look out for our deliverables to be coming soon.